The implied consent law. The implied consent law is a legal concept that holds that by operating a motor vehicle on public roads, drivers automatically give their consent to chemical testing of their blood, breath, or urine to determine their blood alcohol content if they are arrested for driving under the influence. The purpose of the law is to provide a means for law enforcement to test drivers for alcohol or drug impairment, and to deter individuals from driving while under the influence. The history of the implied consent law dates back to the late 1930s and early 1940s, when states began to adopt laws requiring drivers to submit to chemical testing as a condition of operating a motor vehicle. The first state to adopt an implied consent law was Minnesota in 1939. Since then, all states in the United States have adopted implied consent laws. The laws have evolved over time, with changes in the legal limit for BAC, and the addition of implied consent laws for drugs. When a driver is arrested for DUI or DWI, they are required to submit to chemical testing as a condition of operating a motor vehicle on public roads. If a driver refuses to submit to testing, they may face penalties such as license suspension or revocation, fines, and even jail time. Additionally, some states have no refusal laws, which allow for a warrantless blood draw if the driver refuses to submit to testing. It's important to note that while implied consent laws impose certain obligations on drivers, they also provide certain rights. Drivers have the right to choose which type of chemical test they wish to take, and to consult with an attorney before submitting to testing. Drivers also have the right to challenge the results of the test in court and to request an independent test at their own expense. It's important for drivers to be aware of their rights and obligations under the implied consent law and to consult with an attorney if they are arrested for DUI or DWI.